Hi, this is the Business Guy. So what's the difference between fraud and fraudulent transfer? Well, as it turns out, there's actually a huge difference between the word fraud and the term fraudulent transfer. The definition of fraud is wrongful or criminal deception intended to result in financial or personal gain. We define fraudulent transfer, however, as an effort to avoid debt by transferring assets to another person or company. It is generally a civil matter. So fraud occurs when somebody willfully employs deception for personal gain. Judges hear fraud cases in criminal courts for the most part. In contrast, civil courts generally hear cases having to do with fraudulent transfer of assets. And so you can have the latest information in your court. Click subscribe below and the notification bell so that when new videos come out like this, you'll be up to date right away. I'm the CEO of Asset Protection Planners, the nation's largest asset protection firm, and have been in the field for 32 years. The bottom line is that unless someone has protected the assets, creditors can reach assets deemed fraudulently transferred. However, when you have protected your assets, a fraudulent transfer ruling is generally like a barking dog in a cage. So in most instances, it is only those assets that creditors are seeking for which the judge denies protection. That is, the judiciary denies protection unless one holds those assets in the proper asset protection tools. Thus, protected assets remain secure along with the unclaimed assets. The American Bar Association says only the portion of a fraudulent transfer that is necessary to satisfy a creditor's claims is avoidable under the UFTA. That's the Uniform Fraudulent Transfers Act. So if the judge rules that you fraudulently transferred assets, it does not generally mean that you're about to get locked up. On the other hand, it can cost you a lot if you're not prepared with a proper asset protection plan. When you have safely tucked your assets away in a solid asset protection structure, a fraudulent transfer ruling simply consists of words on a paper, but is usually of no real consequence to you. So the dog can bark, but it cannot bite. Now, ideally, you will have set up your asset protection plan before a claim arises. Live an asset protection lifestyle from the get-go, and you won't typically have to worry about a fraudulent transfer ruling. That's the best way to prevent such a claim. Then how do I protect myself? In addition, you are best protected when the heart of your asset protection plan is centered on an offshore asset protection trust and offshore LLC, along with a secure offshore bank account. Now, if you're wary about offshore banking, think again. Do a search for the world's safest bank. You'll clearly see that there are far safer banks outside the US than inside. Don't get lulled into a false sense of security. Your most dangerous bank is a US bank when you have a judgment entered against you. It's like shooting geese in a pond, and that goose doesn't have to be you when you have a robust international asset protection plan in place. Moreover, assets you have secured years ahead of a claim have great advantages. That is, you will likely have surpassed the statute of limitations on fraudulent conveyance. Therefore, creditors will be unable to make claims against such transfers when the statute of limitation period has expired. Think you waited too long to put a plan in place? We have tens of thousands of clients who thought they had. But fret not, there are methods one can use to protect assets after the fact. Just know that doing so beforehand will put you in a better position. Having a solid asset protection strategy is an important part of financial planning for any wealthy individual. Claims of fraudulent transfer pose the greatest possible threat to an unsound asset protection structure. So that is why it is important to have your asset protection structure prepared by an experienced organization. In fact, our company was originally formed in 1906, and I've been in the asset protection profession since 1991. Now, as we continue our discussion here, we'll talk more about what fraudulent transfer is and the best way to avoid it. In spite of the F word that may throw off the layperson, fraudulent transfer that we are discussing here is a civil matter, not a criminal one. So what is a fraudulent transfer? Fraudulent transfer of assets occurs when a person makes a transfer of assets with the explicit intent to delay or defraud creditors. Fraudulent transfer of assets is often called fraudulent conveyance. The law governing fraudulent transfer of assets in the United States is under the Uniform Fraudulent Transfers Act, or UFTA. In 2014, the Uniform Law Commission developed its viable replacement, the Uniform Voidable Transfer Transactions Act, UVTA. The new act more accurately represents its civil nature. Now, there are two types of fraudulent transfer. There is actual and constructive fraud. A transfer made to an asset protection structure in order to render a debtor insolvent constitutes actual fraud. Now, keep in mind, this is a legal term in the context of fraudulent transfer. So again, we're talking about a mere civil matter, not a criminal one. The debtor's intent to defraud the creditor is proven in a successful fraudulent transfer claim. The jurisdiction where the asset protection structure is held determines the burden of proof required. Constructive fraud, on the other hand, occurs when a debtor unloads assets for less than a reasonably equivalent value. This would include selling assets to friends or relatives for far less than they are worth or gifting them away. Debtors and creditors will commonly argue about what is considered reasonably equivalent value for contested assets. Jurisdiction matters. Asset protection structures, including trusts and limited liability companies, are subject to the laws of the jurisdiction in which they are held. There are a number of reasons why it is preferable to use an offshore jurisdiction over a domestic jurisdiction for asset protection planning. The most important reason for using an offshore jurisdiction has to do with fraudulent transfer claims. And that is because most of the leading offshore jurisdictions that specialize in asset protection do not recognize foreign judgments. Creditors are required to travel to the jurisdiction where the asset protection structure is held and have their case heard by the local courts. This means airfare, hotel rooms, and legal fees for your opponent. Creditors are usually discouraged from making claims of fraudulent transfer in offshore jurisdictions because the cost and time required are very high. If a creditor does try to bring a claim of fraudulent transfer in an offshore jurisdiction, the odds are not in their favor. Offshore jurisdictions tend to have much higher burdens of proof than domestic jurisdictions. The burden of proof for claims of fraudulent transfer lies firmly on the shoulders of the creditor in offshore jurisdictions such as the Cook Islands and Nevis. Creditors must prove beyond a reasonable doubt that the debtor intended to defraud them specifically as opposed to any other creditor when they transfer their assets. They must also prove that making the transfer rendered the debtor insolvent. In addition, statutes of limitations in offshore jurisdictions are generally much shorter than the statute of limitations in domestic jurisdictions. In some of the most favorable jurisdictions, such as the Cook Islands, the statute of limitations on fraudulent transfer claims is as short as 1 or 2 years. Once the statute of limitations has passed, the creditor is no longer able to make a claim against a transfer of assets held in an offshore asset protection structure. How to avoid fraudulent transfer? Individuals looking to protect themselves from fraudulent transfer claims should take the following steps. First, pay attention to timing. Timing is a very critical component to avoiding claims of fraudulent transfer. The importance of timing of transfers are twofold. Creditors frequently use timing to establish the intent to defraud. A person who makes a transfer when it was reasonable to assume a creditor could make a claim on those assets is likely to face fraudulent transfer claims. Claims of fraudulent transfer are likely if the transfer was made when one could reasonably anticipate that a creditor will make a claim on those assets. Situations where it is reasonable to assume that creditors will make a claim include after defaulting on a loan or immediately before filing for a divorce. So what if you waited too long? Don't fret, there are excellent international options that can protect assets after the fact. An offshore trust has a trustee company/law firm that operates outside of your court's jurisdiction. The trustee company can refuse to turn over assets to your enemies at law. Remember, fraudulent transfer in this context is a civil matter only, not a criminal one. Number 2, avoid insolvency. Another major component which affects fraudulent transfer claims is whether or not the debtor is solvent. If a transfer of assets renders a debtor insolvent for the purpose of satisfying a creditor's claim, it is possible that the transfer will be deemed fraudulent. It is advisable that individuals avoid making transfers which could make them unable to repay their debts. However, if this is in an international structure, such as an offshore trust, that argument is deemed moot. Number 3, keep intentions above board. Branch Banking and Trust Company versus Hamilton Green LLC is a good example of the effective use of a Cook Islands trust for asset protection. In this case, BB&T lent $3.375 million to Hamilton Greens LLC in 2006. Richard Bellinger and 2 other individuals personally guaranteed the repayment of this loan. And you know what happened a couple of years after this? The global financial crisis. As such, in February of 2011, Hamilton Greens LLC's defaulted on the loan like so many people did during that era, and BB&T filed a suit against Richard Bellinger and the other other individuals in May of 2011 to enforce the personal guarantees. BB&T tried to obtain a summary judgment in their favor on July 1st, 2011, but were denied so that the other parties could complete their discovery. In November of 2011, Richard Bellinger established an asset protection trust in the Cook Islands. He funded the trust with $1.7 million of his personal assets. And then in January of 2013, a $4.9 million summary judgment was levied against Bellinger. Naturally, Bellinger did not pay the ordered amount. And then in August of 2013, BB&T attempted to make a claim of fraudulent transfer of assets against Richard Bellinger. Bellinger testified that he created the trust for his future financial security and to protect against potential claims from his ex-wife. In the Cook Islands, the burden of proof for fraudulent transfer claims is beyond a reasonable doubt. So BB&T had an obligation to prove beyond a reasonable doubt that Bellinger made the transfer fraudulently. They had to prove he did so with the intent to defraud them specifically, but they were unable to find evidence or testimony which proved intent to defraud BB&T. So remember, when you set up a Cook Islands trust, never say, "I set up this trust to protect my assets against you, Mr. Creditor." As a result of this lack of evidence, Richard Bellinger won the case and his $1.7 million in personal assets remained protected in the Cook Islands Trust. Based on the timing of the transfer, it would certainly appear that Bellinger made the transfer in order to avoid paying BB&T Company. Had the burden of proof been clear and convincing evidence, which is 51% to 49%, which is the burden of proof in most civil cases, the verdict may not have been as favorable. So clear and convincing evidence is the burden of proof in most domestic jurisdictions. However, short of a sworn confession, it is next to impossible to prove intent beyond all reasonable doubt. The Bellinger case is a testament to the strength of the protection provided by the Cook Islands Trust. Had Bellinger abided by the trust best practices and transferred his assets earlier, his defense would have been even stronger. In fact, his opponent would not have even been able to bring the case in the Cook Islands. Number 4, consult a professional. Asset protection planning frequently involves the use of complex structures which require knowledge of the laws in multiple jurisdictions. Believe me, I've been in this business for 32 years. I know that to be a fact. Failure to know the law or establish asset protection structures properly can result in claims of fraudulent transfer. The laws regarding transfer of assets are subject to interpretation and are not always clear or easy to understand. Using offshore structures requires knowledge of the laws of multiple jurisdictions and how they interact with one another. Individuals will often find it was worth it to spend the money up front on a solid asset protection structure. Seeking help from qualified asset protection specialists is the best way to avoid claims of fraudulent transfer. For more free information, visit assetprotectionplanners.com and fill out a free strategy session form on our website. Subscribe for more. This is The Business Guy.